what to do in a probate situation. We're going to try to cover all the situations for you guys who are out there who don't know what to do if someone passes away. So today we're here with senior probate attorney Katerina Vita.
Hello.
Thank
How
you for
are
coming.
you? Hi, everybody.
Please tell the audience, what you do and why you do it.
So I've been practicing law since 2005, and so it's been a while. It's about 19 years, and I do trust and probate litigation, and conservatorship litigation as well, and contested guardianship. So this is really what I focus on, and I love doing it.
Okay, so let's try to go through these situations for the people out there. Let's talk about situation one. People are unfortunate enough to have someone pass away, and there are no documents. There's no will. There's no trust. What can that person do?
Well, first, I think we have to figure out how large the estate is. So if the estate is less than 180 or up to 184,500, then they have a lot of options as far as filing affidavits with banks or affidavits with courts if it concerns real property. So the characteristic of what the property is, the decedent's property is left, is it matters. And then if the estate is larger than 84,500, then we have to open probate unless the estate is in a trust. Yeah.
Okay, so that's good. So people out there, if the value of the estate is below 184,000, consult an attorney. You may not have to go to probate at all. That's right?
That's correct. Yes, you may actually file an affidavit, which you have to wait 40 days. First, you have to be the successor in interest. There are certain provisions that need to be included in the affidavit, and then you file that with a bank. Now, if it concerns real property, then the real property cannot be exceed the value of 61,500, and that affidavit has to be filed with the court. If the real property exceeds 61,500 and it's still less than 184,500, then you can file a petition to determine successorship to the real property without opening probate. So it's a simpler, faster procedure.
So for people out there who are wondering, like, what do I get? Like, what if your parents pass and you have siblings and they don't have a will or trust? Who gets what in that situation?
So it depends, again, how many siblings there are. Basically, the lineal descendants get it, so it's by succession, intestate succession, and it's divided based on per stirpes, so basically by representation. Also, if the decedent leaves a surviving spouse, then they have to consider whether there's community property or real property, because the surviving spouse has certain rights, and then the family gets the rest.
Okay, so if someone passes away without a will, the statute kind of tells us who's going to get what. I mean, they need to go to an attorney, but the statute is going to basically advise us on. They're not out of luck. The statute is going to tell us who gets what, depending on their position in the family.
Yes, it's definitely decided by Probate Code Section 240 statutory determination. So the court is going to decide that.
Okay, so what happens when someone passes away and they do have a will? So they have a will, and you don't have to be an attorney to know if someone has a will. They're going to try to articulate in that document who's going to get their stuff, right? So they have a will, and they don't have a trust. So then, what happens to basically try to carry out the wishes of the person who wrote the will?
So first, the will has to be probated. And again, if the assets exceed 184,500, then you have to open probate and you file a petition to probate the will and appoint an executor. Usually the will has a nominee, an executor nominee, so that person usually files to open probate. That's how you start probate, and you have to admit the will. There are certain procedures involved in terms of admitting the will. Usually it has to be signed and witnessed by two independent, well, they don't have to be independent, but usually they have to be two witnesses who see the testator sign the will and basically acknowledge the will being the lost will.
Okay. Now there are some people out there who have a situation in which they believe that the person who was appointed the executor of the will is not doing what he or she should be doing. If you're one of the beneficiaries and you have a concern about the person that was appointed to be an executor, what are your remedies at that point? What are your options?
Well, it depends at which junction of the proceeding. So basically, if you don't want the person to be appointed as executor in the beginning, then you file objections to the petition for appointment of executor, and you explain to the court why. If it's later on in the proceeding where you find that the executor may not be fulfilling his or her duties, then you can file a petition to remove the personal representative for cause.
I see. Okay. So you have a situation, there's a will, you're in probate, there's an executor, you're trying to carry out the wishes of the person who wrote the will, right? Okay. So let's talk about the situation in which there is a trust involved.
Okay.
And so what happens in that situation as far as court involvement and things of that nature when someone has a trust?
Well, the advantages of a trust usually are that you can maintain the administration of the estate post-death private. But things can go wrong when a trustee is not following what perhaps the terms of the trust, is breaching the trust, so you may have to go to court, and at that point it becomes a court proceeding. But sometimes it does not, and it's a private transactional situation.
Okay, so you're saying if things are copacetic and the trustee is doing what he or she should be doing, then you may not have to go to court at all when there's a trust involved?
That's correct, yes. And that's an advantage. It maintains privacy for everyone. And that's probably what the settlor wants to begin with. And you can also avoid probate that way. That's the whole purpose of a trust, is to avoid probate. Because probate can take a long time. So in order to speed up the distribution, speed up the payment and administration of certain issues, usually people establish trusts.
And are there any economic advantages to using a trust over, are there tax issues and things of that nature?
Yes, absolutely. So first of all, the trust can, if you have a two-person trust, usually like a family trust, a trust A and B, then you can save taxes on providing certain tax benefits to the surviving settlor or to the first settlor to die. So the trust definitely provides tax benefits, estate tax benefits. And then you avoid probate, so you save a lot of money on probate costs.
Are there probate taxes?
Well, it depends how big the estate is, but usually the trust saves property from probate taxes, yeah.
I see. Okay, so what happens when you have a situation in which, people are, and this happens a lot, where they're fighting, right? The family members are not happy about what's going on. Mm-hmm. And they are just, everyone is upset about the trustee. They're upset about, what someone may have done to the person that wrote the trust. So there are certain times in which, I know you know this, where people allege that the trust was written under circumstances that weren't appropriate. Can you talk about that?
Yes, so, and it happens a lot, but that would be a trust contest. So basically, if someone believes, and usually it's a disgruntled beneficiary who is removed from the trust, if someone believes that the trust is the product of lack of capacity or undue influence or fraud, they can file a trust contest. However, they also have to be careful not to trigger the no contest clause. So if they are actually getting a gift under the trust, they should think carefully before they actually contest the trust to get more, because that's usually what they believe that they should be getting.
Could you say sometimes there's a clause in there that basically says you're disinherited if you challenge the trust?
Exactly, yeah.
That's terrible.
Yeah,
Oh.
yeah.
I see.
But unless the law has changed quite a bit in the past, and if you have probable cause, you're usually safe in contesting the trust. However, probable cause is discretionary, so it depends on the judge. So you have to still think carefully about it.
Okay, and can that person make the same type of challenge to a will? And what does that look like?
Yes, so you can challenge a will. So first, the burden to get will probated is on the person who's admitting the will. But when you're challenging the will, the burden falls on the challenger. And if you're challenging the will based on undue influence, it's it's clear and convincing evidence, so it's a high standard. If you're challenging it based on other causes like forgery or lack of capacity, the standard is lower, it's preponderance of evidence. So you can do the same thing with wills.
So these fights that occur in probate court or over a will or a trust, I mean, typically how long do they last? I mean, your situation where let's take it where someone is contesting a trust or will, the way it was written or the circumstances under which it was written. Is that something that's resolved in a week, 2 weeks, or what are we talking about?
Yeah, unfortunately, it's not that easy. First, I mean, the contest can take months, sometimes even years, depending on the complications. Yeah, and unfortunately, the process starts out with the contest. You file the contest, then you go through the discovery phase, then you can go to mediation or not arbitration, but mandatory settlement conference. And if that doesn't work, then you go to trial. And the schedule really depends on the courts because the courts are overwhelmed with cases. So it's moving slow. The courts are backed up now, especially the probate courts.
So how does settlement work? You did mention settlement. Like, where is the opportunity to settle usually in these cases, and what does that look like generally?
So after the pleadings are filed, and let's say you file a trust contest, you're going through the discovery, the judge will then ask you whether you would like to participate in mandatory settlement conference or a private mediation, and you can choose one or the other, or even both if one doesn't work. Mandatory settlement conferences are usually court regulated, meaning you get a date from the court and you don't pay. Versus a private mediation is something that you split between the parties or sometimes the trust. If you're dealing with a trust issue, the trust pays for the private mediation. And it's about, the mediation process is very good because it provides you with control over the outcome rather than if you go to trial, even if you think that you have a very strong case, you still are taking the risk of not having the judge not see it your way. So the mediation really secures the outcome within how you see it.
I see. So generally, how does it, I mean, from your experience, when you have a large family, I mean, does it typically, align in a way that a lot of family members are against one person, or are they always split? Do they all have their own attorneys? Generally, how does it usually play out?
It depends. I mean, I've had cases where you've got 2-3 family members and they each are represented. And in that case, that works well. Actually, when you have representation, it works better because each family member gets guidance on their rights, their liabilities, if there are any, and whatnot. But I've had a case where there were about 25 family members and only 2 were represented. So in this case, we were able to settle the case, but we were lucky because the Breslin case was issued, and pursuant to the Breslin notice, which gives authority to the court to order a mediation and compel all of the beneficiaries to attend the mediation. So, and if they don't, they could lose the benefit under the trust. So that allowed a case that had 20 beneficiaries which were not represented to participate or compel them to participate and resolve it.
So what do you say to the person out there who believes they can represent themselves in this type of environment where they're in probate and the family members are arguing over certain things and they believe they've been cheated out of their portion? How important is it, if at all, to get an attorney?
I think it's one of the most crucial things you could ever do. I would even suggest that attorneys get attorneys because it's extremely important to know all of your rights and all of your claims and whether your claims are valid or not. And then the attorney can guide you through the process through an objective perspective. Because when you're a client, when you're actually representing yourself, you see things subjectively. And that can sometimes, your perception can be twisted, for lack of a better word, and you may not act in your best interest. So when you get a good attorney and that attorney is obligated to act in your best interest, you will have a good outcome, or you should have a good outcome.